Hey, everybody. It's Wednesday night. Hope you're all doing well. We're doing great here, finally inching up above freezing in Idaho. It's been very chilly here, been down in the single digits and well below freezing for days. We've had quite a bit of snow, a little bit more than is typical for the Boise area. So we're looking forward to getting up above freezing for the first time in a couple of weeks and digging out a little bit. We probably had another 3 to 4 inches of snow today. And I can tell you my dogs are ready for the snow to go away so they can go out and play. My little old Chihuahua is not a fan. He is, we think around 13 or 14. We're not sure because he was a rescue. He was my mom's dog. And so he lives part-time with me and part-time with my mom over at her assisted living. But he is not a fan of the snow. Loved living in Arizona where he could lay out in the sun, and he does not like wading through the snow to go to the bathroom. So he's going to be quite happy once he can see the grass again. Welcome to anybody who's new to our channel. I'm Lori Hellis. I'm a retired criminal and family attorney, and I am writing a book about the Vallow Daybell case. The manuscript, the initial manuscript, just went to my publisher last week. Yay! And now I'm working on the marketing piece of it and waiting for feedback back from my editor. So the book will launch for pre-sales at CRIMECON, which is May 30th through June 1st in Nashville, Tennessee. Hope as many of you as possible will join us there. And I want to remind folks that they look for volunteers. So if you're somebody who would love to go but finds the tickets to be a little pricey, volunteer and you get a ticket. So we're going to be there with a booth and handing out some swag and signing book plates for advance purchases. And so we're really looking forward to meeting as many people as possible. I'm looking for help. So if you are somebody who's going to attend, let me know. Just kind of waiting and let the chat catch up a little bit. I did want to let folks know that Michelle is not going to be working with me anymore. And I wanted to let you all know that I appreciate so much your support for her. And all of the donations that you've made until today that were earmarked for Michelle will go directly to her. Just want to assure you that we will forward any of those donations on to her for anything that happened until today. Thank you for your support for her. I know that she appreciates it more than she can say. I also want to thank Jen, who's stepped in as our moderator. And I appreciate all her help as well. Well, we are going to take a deep dive into Murdaugh. For those of you who might not know, there was a hearing on Murdaugh that happened yesterday morning, and I'm here to tell you it is juicy. So for those of you who are law nerds, as Emily D. Baker calls her followers, those of you who really like to get into the nuts and bolts of the law and the wherefore and the whys of what happens in courtrooms, tonight's your night. Because we are really going to deep dive into the law. So let me just give you a little bit of a refresher on what's been going on with Murdaugh. You might remember that Alec Murdaugh was a prominent lawyer in South Carolina. He was accused of a number of financial crimes, millions of dollars worth of financial crimes, which the prosecution said served as the motive for him to murder his wife and his son. And he went to trial. There was a 6-week trial. And at the end of that trial, he was found guilty and he was sentenced to life life in prison without parole sentences. Following that, he pled guilty to a number of the financial crimes and received an additional 27-year sentence for the financial crimes. So not very long after that, his attorneys, well, actually prior to that, his attorneys, Dick Harpootlian and Jim Griffin, who I affectionately refer to as Pootie and the Grifter, filed a motion. They initially had filed a notice of appeal with the South Carolina Supreme Court. Then they filed a motion with the court asking the court to set aside or to put that on hold because they wanted to file a motion for a new trial based on the fact that they believed that there had been jury tampering by the clerk of the court. Now, the clerk of the court's name is Becky Hill, and she was the person who ran the trial there in Colleton County. Colleton County is a small rural South Carolina county. So the appeals court granted their request to put the appeal on hold while they pursued a new trial. So they filed motions with the court, asking the court to set an evidentiary hearing based on their allegations that there had been jury tampering. And one of the things they said was that they anticipated that Judge Clifton Newman, who presided over the murder trial, was going to be a witness in the case. And so Judge Newman recused himself from the murder case. He did remain on the financial crimes case, and that case was set for trial when Murdaugh decided to enter a guilty plea. So he pled guilty and was sentenced on those charges. Judge Newman is now completely out of the case because the financial crimes are done and he has recused himself from the murder case. So the current Chief Justice of the South Carolina Supreme Court appointed Judge Jean Hofer. I want to get this right. Hofer Toll is her name. Judge Toll is the former Chief Justice of the South Carolina Supreme Court up until 2013. Judge Toll was a practicing attorney. She was a citizen legislator. She was in the South Carolina legislature for some years, and then was appointed to the South Carolina Supreme Court. She was the first woman appointed to the South Carolina Supreme Court and the only woman to ever hold the position of Chief Justice. Now, the Chief Justice of a state Supreme Court is more than just the head of the Supreme Court. When we think about the Chief Justice of the federal Supreme Court, we recognize that judge is that position is the person who oversees the operation of the federal Supreme Court. However, in state Supreme Courts, the Chief Justice not only oversees the operation of the state Supreme Court, but she also is the chief judicial officer in the state, meaning that she sets policy for all of the lower courts as well. So she is the person who issues trial court rules. She is the person who sets policy for how the trial courts run, as well as overseeing to make sure that cases are proceeding through the trial court at a reasonable rate. So there's a lot more to being Chief Justice of a state Supreme Court than just running the appeals court. That in itself is a big job, running the state Supreme Court, but there's much more to it than that. So Justice Toll was the Chief Justice for quite a few years. she retired from the court because they have a mandatory retirement age, but she has continued to provide to work as a senior judge. Now, in most states, what happens is judges can retire at a minimum age, but if they do, in order for them to receive their full pension amount, they need to continue to operate as a senior judge for so many hours a year. So Justice Toll has continued to serve as a trial court judge, where she has been overseeing a lot of the asbestos litigation in South Carolina. Local lawyers there say that she is an intellectual giant. She is a really brilliant woman. She is a really smart and no nonsense kind of a judge. And one of the things that I think has been interesting is that South Carolina is still a little bit maybe behind in terms of women in their attitudes towards women in professional positions. But she's a very no-nonsense judge. She's very clearly controls her courtroom. So I want to talk a little bit about the difference between trial courts and appellate courts, because they run differently. So in a trial court, the lawyers really decide how the case proceeds, and the judge really is there, particularly if there is a jury, to call balls and strikes, to be able to say that comes in, that doesn't come in, that objection's overruled, that objection is allowed, and to enforce the rules of the state rules of evidence. So when a case goes to the appellate court, the appeals courts are much more directive, and it is much more of a question and answer process between the judges and the lawyers. So the first thing that happens is you file a notice of appeal. The appellate court then gives you a briefing schedule, and the moving party then files an opening brief. The responding party files a response. There might be rebuttal and surrebuttal, and then the court either makes a decision based on the briefs or schedules a time for oral arguments. If the court then allows oral arguments, because not every appeal goes to oral arguments, some of them are decided and affirmed without any opinion. So if it goes to oral arguments, then the attorneys appear in front of the justices, and there is a question answer sort of exchange back and forth about the questions that are on the minds of the appellate justices. So it's a much more appellate judges are much more involved in the process than a trial level judge would be. And that is to some extent the way that Judge Toll runs her courtroom. So it was very interesting to see this. So the first thing that happened was everyone comes into the courtroom. Alec Murdaugh was brought into the courtroom. He was in an orange jumpsuit. He was in handcuffs because there's no jury present. So he's not in civilian clothes or being protected, the perception of him being protected. So he appears in court, everyone sits down, and the judge then gave some opening remarks, which is not always typical in a trial level case. But she went through the timeline of what happened, when things were filed, when she was appointed, and the issues that were in front of her. So it was very interesting. I thought there was another interesting little quirk with Justice Toll. She married her law school classmate. They have been married ever since, and they were the only husband and wife uh, law review editors. Now, for those of you who are not familiar, editing the law review at any law school is a really big deal. Getting on to the law review, which is a publication which is put out by each law school. Often they're very specialized. For example, the law school I went to, the law review strictly has to do with environmental law. There are some law schools where their law review only has to do with family law or commercial law. So, but it's very prestigious to have been selected to be on the law review, to contribute to the law review, let alone to be the editor. So she and her husband were the co-editors of the law review. And that's definitely the way she started out her career. So the other thing I wanted to talk about before we sort of got into the nitty-gritty of the hearing is when lawyers make arguments, how do we figure out what the rule is? What's the rule really? Because Creighton Waters came into court and said, here are the cases that I think are controlling, and I think give the court direction on how to make these choices. And Dick Harpootlian came in and said, no, we want you to use these cases. So the first thing that happens is when a lawyer is looking at an issue, and in this case, the issue is what's the legal standard for deciding a jury tampering case. So in this case, they both went to the law library, which is now all digital, and researched all of the cases having to do with jury tampering or with any kind of jury misconduct or attempt to influence the jury. And so they looked through the cases, and as is often the case, each of the lawyers looked for cases that supported their argument, which was Creighton Waters said, you have to prove that there's been actual prejudice to Mr. Murdaugh. And Dick Harpootlian and Jim Griffin said, oh, no, we only have to prove that it happened, and then you have to prove that it was harmless. So there's a big difference in those two standards. And so the judge then, because Judge Toll is a very learned appellate lawyer, looked through both of their briefs, their memorandum on their side of the case, read all of the case law, and studied it and made a decision on which cases she felt were the most applicable to this case. So when a lot of it has to do with how recent the case is versus how old it is, whether it's been overruled by the U.S. Supreme Court or by the state Supreme Court, whether the facts of the case fit the facts of the case we're arguing about. So the closer the facts are to the facts in the Murdaugh case, the better. The more recent the case is, the better. And then what is the highest level of court that made that decision? So a case that was a decision that was issued by the state appellate court isn't going to have as much weight as a case that was a decision that was issued by the Supreme Court. Because typically what happens is a trial court issue is appealed to the appeals court. The appeals court then issues a decision. If you disagree with that, then it gets appealed to the state Supreme Court. If there is a federal question, there has to be a way that this case impacts a federal question. If there is a federal question, you may very well be able to elevate that to the U.S. Supreme Court. So As they were having these conversations, the as is typical, the prosecution and the defense disagreed about what case would be the controlling ruling, what case would be um, most persuasive for the judge. Where's the rule? So the judge started out by giving this outline of where they were, sort of what we usually call the procedural posture of the case. Where are we right now? And a little bit of a sketch of how we got here. And then the next thing that would happen is the next thing that happened was the judge then said, I'm going to identify the three things that I want to accomplish today. The first thing I want to do is I want to know what I want to know what the legal standard is. And we're going to have this conversation about what the legal standard is. And I'm going to get deep into this because it's important. And this is where the juiciness is. And I think that the average person listening to the hearing may not have seen the juiciness because some of it has to do with the legal issues. But so we're going to get deep into that. So the judge said, the first thing I want to talk about is the legal standard. What standard do I need to apply in order to make a decision? The second thing I want to know is the second issue is that the prosecution has said that the defense didn't bring their challenge in a timely way, that they should have brought it within 10 days after the trial. Now, the defense says we didn't learn about that information in time to meet that deadline. So there is a provision that says it has to be 10 days or when you discover the new evidence being the evidence that of the jury tampering. So the third thing the judge wanted to talk about was the procedure that she was going to follow in questioning the witnesses. And this is important too, because there was some juicy decisions that came out of that. So Jim Griffin was the one who gave most of the defense presentation. And he said, the first question is an evidentiary hearing necessary? He said, of course, one is necessary. Now, I think this is a moot point because the judge has already scheduled the evidentiary hearing. And by the time we get to the end of the hearing, it's very clear that the evidentiary hearing is going forward. And it's not a super high burden to figure out whether or not you need an evidentiary hearing. The judge really just has to decide, yes, there are issues for which I need to hear testimony in order to make an informed decision about the defense motion. So the biggest question for the judge was, what is the legal standard? And this was where the arguments got interesting if you're a legal wonk. So the first thing that happened was the defense said, we rely on a case called Cameron, which is a South Carolina State Supreme Court case, but which referred to a case called Reamer. And Reamer was a U.S. Federal Supreme Court case on the issue of jury tampering, but it goes all the way back to 1954. So what the defense wanted the judge to do was rely on the rule from Reamer as it had been confirmed in Cameron. Now, Cameron was a case from the 90s. And Judge Toll then So I'm sorry, Griffin then made the argument that all of the other contemporary cases that came after this Kramer case were merely interpreting Cameron and Reamer. Well, the judge wasn't having it. She didn't buy it. She said there were a number of, first of all, she said, I am going to be following the jurisprudence of the South Carolina Supreme Court. So what she was saying was, I don't care what the US Supreme Court says. The South Carolina decisions in the South Carolina court are going to control. Now, there's nothing that indicates that those two, that they conflict in any way, because there are many more contemporary cases. There are many more contemporary cases in the US Supreme Court than Reamer. So she made very clear from the outset that she was not going to be relying on Reamer, the rules in Reamer, to make a decision. And that was really, really important, because Reamer does a funny thing. And this is a thing that courts do not like. The law, the statutes, and the Constitution, which is where we start. We start with the US Constitution, and then we put in place laws that operate to enforce the Constitution. That's really how laws get made. We look at, among all of the things that we want to have happen in our state, they all have to fall under the umbrella of the US Constitution. So the law, as it's been established in South Carolina, says that if there is juror misconduct, it must be proven that there was prejudice. This is very different from the decision in Reamer that was reinforced by Cameron. I'm trying to keep these all straight for you because it does get a little convoluted. So one of the things that the judge said was, I believe that I don't like any rules that shift the burden of proof. So we're going to talk about burdens of proof. In any case, the burden of proof is, in a criminal case, is on the prosecution. Now, in a civil case, the burden of proof is on the plaintiff, okay? In a case like this, which is really a civil action about a criminal case, if that makes sense, the burden of proof is on the moving party. So when you file a motion in court, the burden to prove the basis of your motion falls on you. But what Griffin and Harpootlian were saying is, oh, no, all we have to do is prove that there was contact between a government official and a juror. And that then shifts the burden to the state to prove that that conduct was harmless. That is what Cameron and Reamer, the proposition that they stood for. And the judge said, that is outdated law. I am not going there. I am not going to use that as the standard. I don't believe in burden shifting. It is purely the defense's burden to prove that there was prejudice. This is huge. It is juicy, because now Harpootlian and Griffin have to sit down and prove by clear and convincing evidence. So let's talk about that a minute. There are three legal standards: beyond a reasonable doubt, which we usually say is like 97 to 98% sure; clear and convincing, which we say is like 71 to 75%; and a preponderance of the evidence, which is 51%, just more likely than not. So in this case, they have to prove by clear and convincing evidence, so 71 to 75% certain that the contact with the jurors occurred, but more importantly, they have to prove that it prejudiced the decision that the jury made. That's huge. So all along, Griffin and Harpootlian have been saying, oh, no, all we have to do is prove that it happened. And then the state is going to have to prove it wasn't prejudicial. And the judge said, I don't think that that is the appropriate standard. I don't believe that the legislature or the case law intended for the burden to shift. And so I'm not shifting the burden. You are the one who made the motion, and you have the responsibility to prove that the prejudice happened. So that was huge. The next thing that happened, which was also huge, was then the judge got into, well, if we are going to have an evidentiary hearing and we're going to hear witnesses, what witnesses and what evidence must we hear? Interesting. Yeah. So what she said was, I will only hear from the jurors who were seated and deliberated. Now, and the clerk of the court. What Harpootlian and Griffin wanted was to bring in all these other witnesses. They wanted to bring in the alternate jurors. They wanted to bring in the egg lady, the juror that was dismissed for having talked about the case with friends. They wanted to bring all those other people in because that's where they got their information. So we don't know what the egg lady's intention was. Was she kind of sour grapes because she got thrown off and it was embarrassing? What the alternate juror that didn't deliberate might have been somebody who thought they would have voted not guilty. We don't know, but they wanted to bring in all of those other people. People who could say, yes, I heard her say this, or I heard her say that. What the judge said was, I don't care about anybody who, except the jurors who actually deliberated over his guilt or innocence. Now, there is a statute in North Carolina, as there is in all states, that says that you cannot invade the deliberations of the jury. You cannot question them about their mindset. You cannot question them about what happened in the jury room, who said what, whether they felt pressured. None of that can be discussed. What the South Carolina law says is that you can inquire of the jury whether or not the inappropriate contact impacted their decision. So that is the only inquiry you can make. Did you hear these comments, and did they in any way affect your decision? Griffin and Harpootlian have not provided any evidence that to suggest that, but for Becky Hill's comments, the verdict would have been different, or any juror would have considered a different verdict. So what the judge said was, my questions are going to be limited to what was said, when it was said, and how the juror perceived it. That is a huge blow for Harpootlian and Griffin, because a lot of the stuff that they want to bring in, what did not come in through one of the 12 sitting jurors. So she said, I am only going to question the seated jurors, and I am going to limit my questions to what did you hear, when did you hear it, and how did it impact the outcome? Now, she said clearly the clerk of the court is going to have to come and testify, and she may very well take the fifth. So when the judge said, I'm only going to hear from the 12 seated jurors, then Harpootlian jumped up and said, well, we're going to have to make a proffer then. Now, a proffer, an offer of proof, okay? Proof, offer, proffer. And here's, remember, if you watched the Murdaugh trial, there was a couple of days of financial crime information that was all done as a proffer and then had to be represented to the jury once the judge had made a ruling on whether or not that information came in. So Harpootlian was hoping that he was going to be able to make these proffers, which means presenting evidence that the judge has ruled is not going to come in. Now, remember, this is different because the judge in this case is the finder of fact and the decision maker, unlike the trial where it was the jury. So in the murder trial, where the state wanted to put on evidence of all of the financial crimes as motive for the murders, and Harpootlian said, no, it doesn't come in because it's evidence of prior bad acts under 404, evidence rule 404. And the judge said, well, I don't know how to rule on it until I've heard the evidence. Now, remember, that wasn't the jury that was going to find what was true and not, the finder of fact, and render a verdict. So the judge said, before I can call balls and strikes, I need to know what it is we're talking about. So the state put on a whole day worth of financial crimes evidence before the judge alone, and Judge Newman ruled, yes, I'm going to let all that stuff in. Once that ruling happened, then it all had to be presented a second time to the jury. So in this case, what Harpootlian was trying to do, which is sneaky and cagey, was to say, well, I need to make a proffer because I need to preserve my record for appeals. And so, Judge, I want to tell you all that information that you've now said to me you're not going to accept and is inadmissible. I want to tell you anyway. And the judge said, no, we're not going to do that. If you're going to make a proffer, it needs to be in writing, and I will put it in the court record. And that just threw them for a loop. You could see Alec Murdaugh's face drop. You could see him swallow. You could see his eyes blink. He was clearly stressed out by it. Harpootlian's jaw was locked, man. They were not happy at all. So what she said was, I'm only going to hear from the 12 seated jurors. I'm not going to hear from anybody who didn't deliberate in the case, because the only question I want answered is what was said, when was it said, and did it impact the final outcome, the verdict? And the only juror who was a seated and deliberating juror, her sworn affidavit simply says, I felt pressured by the other jurors. It does not talk at all about any pressure that came from Becky Hill, anything that she said having an impact on that juror's decision. She simply said, I felt pressured by the rest of the jury to vote guilty. That is a very typical circumstance that happens during juror deliberations, and it is off limits. the substance of the juror deliberations, the way that the jurors felt about their deliberations, all of those things completely off limits. So Harpootlian is freaked out because now he can't get that information. He can't get the information from the jurors who say, oh yeah, I heard Becky Hill say all these things. He can't get that in because the judge said, I'm not hearing from those people because they didn't deliberate. The outcome of the trial could not have been impacted by them because they were alternates that or people who got excused before the jury went to deliberate. Huge, huge win for the prosecution. And they're not happy. And they're not happy about the fact that the judge has said, I'm not going to let you, Mr. Harpootlian, stand up here and perform for the cameras, which he accused lots of other people of doing. I'm not going to let you stand up here and perform for the cameras by saying I need to make an offer of proof. I am not going to let you stand up here and grandstand in the name of making an offer of proof. If you have offers of proof that you want to make your appellate record, you do it in writing, we'll put it in the court record, and it can go on up to the appeals court, but you're not going to do it in open court, and you're not going to you're not going to bring in all this extraneous information. So the other thing the judge said was, I only care about what happened during the trial and during the jurors' deliberations. The judge said, I do not care about anything that came up after. So Miss Becky's book, the plagiarism that's in the book, any ethics violations that happened for her misusing, for her potentially misusing funds, anything that happened for her, the potential of her soliciting money for giving tours of the courthouse, all of that ethical stuff, not relevant because it happened after the verdict. So all of those things that Dick Harpootlian and Jim Griffin have wanted to get in to slay the reputation of the court clerk, the judge said, it's not coming in. She said all 12 jurors should be questioned by the judge. The lawyers will not be permitted to ask questions. The lawyers will be permitted, if they believe that there is a follow-up question that needs to be asked of a juror, they will be permitted to, outside the presence of that juror, ask the judge to present that question to the juror. So they are not going to get carte blanche to question jurors. Only the judge is going to question the jurors, and only the judge is going to, and the judge is going to limit the questioning, what the lawyers can ask. She will be the gatekeeper. So she will decide whether or not those additional questions will be asked and in what form. And she will then decide whether or not that information is relevant. And she has already made very clear that she is not going to brook any nonsense, that she is not going to allow in a lot of extraneous stuff. And I think her questions, it was very interesting because she said she was going to question the jurors on the first day, which is on the 29th. And she said, I will question the jurors, and I anticipate that I will be able to question all of them on that day. I think that is because her questions are going to be, did you hear Becky say anything about Alec Murdaugh's demeanor? Did you hear her say anything about the evidence in the case in general? And if you did it affect your decision? Now, I want to remind you that at the end of the trial, as is very typical, the jurors were polled. What that means is each individual juror was asked on the record, is this your considered decision? Yes. Every one of them answered yes. There's no question that at that point they confirmed for Judge Newman on the record that that had been their considered and unanimous decision. So it's a little hard to go back later and say, well, but I was impacted by, I was convinced by Becky Hill. I don't think it flies. And I think that Pootie and the Grifter got their feathers trimmed. They got their wings clipped today. The judge was very clear. And I think that appointing Judge Toll was a little stroke of brilliance, frankly. She is absolutely no nonsense. And there is no one who has more authority, more gravitas, more presence than Judge Toll. She is not going to be swayed and screwed around with by Dick Harpootlian. She's not going to tolerate 1 second of it. And I think it's really interesting. A lot of people pointed out that she's 80 years old. I'm here to tell you she is sharp as a tack. I thought I want to point out that she is not that much older than Dick Harpootlian, and nobody really brings into question his ability to conduct a trial and to be in court. So I don't buy it. I think that there's a little bit of a double standard because she's a woman. The other interesting thing is she has a very deep voice. And when you listen to the recording, you're like, whoa, who is that? I thought that was a woman going to be on the bench. She has a very deep voice. So I think the judge is going to ask very limited questions of each one of the jurors, and she's going to say, I'm satisfied. Every one of the jurors said that, yeah, maybe they heard some things from Miss Becky. No, it didn't really impact their decision making. No, you can't ask them about what happened during their deliberations. And if the jurors say, no, it didn't impact my decision, the discussion is over. So I thought it was really interesting. I thought I got a real chuckle out of the fact that the judge said, no proffers. You don't get to stand up and grandstand and put on evidence to the public that I have said isn't relevant to the question. He was hot under the collar over that. And I think that any other judge might have given him more deference. So I think appointing her was a stroke of brilliance because she don't defer to anybody. She's a honey badger. She's just like, she doesn't owe anybody any deference. Now, I will say that I listened to one of the local attorneys and he said, yeah, I admire her. She's an intellectual giant. I don't really like the way sometimes she takes people to task in her courtroom. I agree that is an uncomfortable position for lawyers. I agree that it probably doesn't have any room in courtrooms, but I also understand that being a woman in that kind of a position might have at times required her to really smack people down in her courtroom. I do believe, and I don't want to make generalizations, but I do believe that there are some of the southern states who are a little bit less advanced when it comes to women in authority. And it may, and she started at the Supreme Court in 1988. So let's remember that she started during a period of time when women were not common in those kind of positions, and where she very much had to establish herself in order to demand the respect that she was due. So I kind of understand where she might have been coming from, although I can't condone any judge who belittles lawyers in front of their clients, belittles clients. I can't support that at all. And believe me, I've been in front of a few of them. But I thought it was really fascinating. So she really clipped their wings, and said, nope, no extraneous information or outside influence. So the other thing that they argued was that the clerk of the court was a party opponent. Now, this is a funny, you've got to really be in the weeds here. But you all hear every time you watch a trial, hearsay, 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 hearsay objections. And if you watch the Valladay-Bell trial, you probably thought, wouldn't that be hearsay? And they let it, and the judge let it in. The reason is that there is an exception to the hearsay rule for the statements made by a party or a defendant. Okay. So there's a rule that says if you're a party to the case, you're not protected by the hearsay rule. So in Lori Vallow's case, there were statements let in where somebody said, Lori told me. Well, anytime anybody's up there saying so-and-so told me, that's hearsay. However, in her case, anything she said to other people could come in under that hearsay exception. So they were arguing that because Becky Hill is a public official, that she is a party opponent standing on the same side as the prosecutor. And the judge didn't give that a second's thought. She said she is not a party opponent. She is a public figure, and she is subject to the rules of evidence, which means that a lot of the things that were said don't come in because they're hearsay. So the other thing that happened was the judge was very reluctant to allow in a lot of extraneous information, including the thousands of emails that went back and forth between Becky and the prosecution, Becky and the defense, Becky and the press, Becky and court staff. So they have decided that she was going to very judiciously review what sort of evidence was going to come in. The upshot was her ruling was the judge was going to question the jurors. Her question was going to be, was improper contact made? And if so, what impact did it have on the deliberations? She said she was reluctant to turn the hearing on juror contact into an inquiry into the conduct of the clerk of the court and all her improper behavior. The inquiry was going to be limited in nature, limited, underlined. She wants all of the questions in advance. She said, I am the judge, and I will determine credibility when it comes to this issue. And I am not going to hear every mistake she's ever made. If she decided to exclude witnesses and exclude evidence, the defense would be free to make their proffers, but they would be in writing. The judge said, I love this part. She said she was happy to give the parties advice on what could be brought in. It was very clear that she was telegraphing to them that this was not going to be a witch hunt, that it was not going to be a wide inquiry into the behavior of the court clerk. And she was not going to allow in a bunch of unnecessary information to impugn the character of the clerk. She also said she was absolutely not going to entertain subpoenaing attorneys or Judge Newman. Neither one would be allowed to be called as witnesses. She was strictly going to limit the inquiry to what happened during the trial and not what happened outside. The judge said the jurors would be questioned in open court. Now, several the lawyers at one point suggested that the jurors be questioned in judges' chambers. The judge said absolutely not. They will be questioned in open court. Court TV will be there to provide a pool camera. That pool camera will not be focused on the jury, never has been in the past. And they will not be permitted to show the jurors' faces. The jurors will be provided transportation if necessary, because this hearing is in a different county from Colleton County. SLED will provide, SLED, South Carolina Law Enforcement Division, that's their state police, will provide transportation if necessary for the jurors. They will come in through a private door. They will be ushered into the jury room, and they will be protected from their identities being known, or from them being harassed by media or anybody else. Now, I mean, they've made the point that at least 3 of the jurors were on Good Morning America, and their identities are obviously known. But they did make the point that, you know, what happens if the judge questions all 12 jurors and determines that juror number 5 says, yes, I was influenced by the clerk of the court, and the judge orders there to be a new trial. Then suddenly that juror is subject to a lot of community scrutiny and perhaps threats. And so she was quite cautious to say that they were going to protect the identity of the jurors. And the other thing is that the juror numbers and their identities in some instances were in some of the emailed released emails. And so it was suggested that once the jurors are in the courthouse, that they renumber them 1 through 12, that they're not still referring to them as juror 560 and juror 720 and the numbers that were used during the trial, because that would further identify them. So I expect that the judge said that's a good idea, and I expect that they'll do that. Is that they will be given juror numbers for the purpose of this hearing, and they will be juror 1 through 12. So with that, I think I have talked for almost an hour about the deep dive into the legal issues in the Murdaugh case. It was, from my standpoint, it was juicy. I was surprised, and it was interesting to watch the reactions of the people involved. I think Creighton Waters kept it very, pretty poker faced, but it was very clear that Pootie and the Grifter and Alec were not happy campers. In fact, when Pootie left the courtroom, the guy who's never met a camera he didn't like charged out saying no comment 5 times. So he was not happy. Fascinating, interesting. This is the kind of drama I like. The social media drama, not so much, but the courtroom drama, I'm here for it. So it was pretty interesting. Jen, I think we're ready to take some questions. We've got 361 folks in the chat. Please go out and hit the like button. And if you have not subscribed, please do. As you found out last week, I occasionally do a surprise live when something big happens. So it's always good to get those notifications. Hi, Carol. And I saw Attorney General in court, so I'm hoping he is contemplating an investigation of this trial and the defense. Well, I don't know. I think the clerk of the court is very embattled at this point. I've heard, although I have not seen anything, that there may be criminal charges coming for her. SLED has confirmed that they've opened a criminal investigation. And I don't really know how much good it does to pile on her. I don't know that they're contemplating an investigation of the trial and the defense. I don't know. I can't say that I saw many things that I thought were very inappropriate and made me dislike Dick Harpootlian intensely. I didn't like the way he was disrespectful of women witnesses. I found him pointing a gun at the prosecution well beyond the pale. And had I been the judge, he would have gotten a sanction for that. But Judge Newman didn't do that. And I don't know that there would be grounds to prosecute anybody else in the case. I don't know. SLED may have way more information than we do, but I'm not sure that there's a basis for any other investigation into the trial or the defense attorneys. But certainly, I think Becky Hill is in deep trouble. One of the things that Dick Harpootlian desperately wanted to get in was that a member of the court staff, and he said this in court, and he said it twice, and the judge finally said to him, "Mr. Harpootlian, I hope I'm not going to hear that again today," which was the first time she really smacked him down. And I thought she did it pretty gracefully, but she was very clear. I don't want to hear that. But one of the things that he said was that there was a member of the court staff who said that Becky said, now we're getting into hearsay again, but that Becky had said to her, I hope it's a guilty verdict because a guilty verdict is good for my book, sells more books. Whether or not that's relevant to whether he gets a new trial or not, I'd say no. That's not a comment that was made to a juror. And so there's no discussion that could have influenced the jury's decision. Sure, I think it's I think it's an ethical question, and the ethics board is investigating Miss Becky, and it might even be a criminal investigation because witness tampering is a criminal offense. But once again, making that comment to a coworker court staff isn't necessarily going to have much impact. But boy, Harpootlian really wanted it in. He really wanted it in. Hi, Angela. Thought I saw online that Poot now wants this new judge removed. Well, that might be possible because he didn't like the ruling, but there is absolutely no basis to remove her. It may very well be possible that he wants her out of there because he didn't like the ruling. But there is no basis, no state in which you can say, I didn't like that judge's ruling, so I want to disqualify him. It's not going to happen. And I don't think it's going to happen. Based on what I saw today, I saw that hearing was absolutely squeaky clean, above reproach in the way that she conducted that hearing. I mean, they can argue all day long that they disagree with her decisions. They disagree with her decision on what standard she's going to use. They disagree about the fact that she's not going to shift the burden. They can disagree all day long about that. But that is a ruling judges make every day. That is not a basis to disqualify a judge for prejudice. It just isn't. So I don't think Dick Harpootlian is going to get anywhere trying to have this judge removed. What I love about this judge is that Harpootlian always plays on his clout. He's a South Carolina gentleman. He's a legislator. He's always playing on his clout, and he rides on that. And they gave him a judge who couldn't care 2 cents about Harpootlian's clout. They gave him a judge who is ironclad. I mean, she could care less. She is impervious to his clout. You know, what are you going to do with an 80-year-old former Chief Justice of the Supreme Court? If she decides tomorrow, well, I'm not going to put up with your BS, I'll just retire. What are you going to do? I mean, she is so invincible in that regard. His clout doesn't mean anything to her. So I love that about it, because South Carolina is a place where clout is everything, as we learned with Alec Murdaugh and his 4 generations of lawyers and solicitors. So it is super important in this case that they have consistently put judges in place that Harpootlian's clout didn't mean anything to. Judge Newman was getting ready to retire, so his clout didn't really have any impact on Judge Newman. And now we have Justice Toll, who's an 80-year-old senior former Chief Justice. She's bulletproof. So I don't know that I just think Harpootlian can't win. He can't win by using his clout. He's got to win by having the better argument, and he's got to win by having the law on his side. He's not going to win because of his influence. Good questions tonight, guys. Hi, is it Rose or Ross? Roz? Won't the jurors be enough to prove or disprove tampering? I think the defense wants to try Ms. Hill, which is not the point of the evidentiary hearing. It will only muddy waters, causing confusion. That's exactly right. And that is exactly what Judge Toll is not going to allow. And that is exactly why Dick Harpootlian is pissed and maybe wants a different judge, because she has made clear, I'm not having it. You are not going to put on a bunch of extraneous witnesses who have no impact on whether the 12 jurors who deliberated were influenced by anything Becky Hill said before or during the deliberations. And that is the only narrow question that she is willing to hear about. So I don't doubt that at this point, Harpootlian would love to have a different judge that he can sort of manipulate more or influence more, but she's not having it. So good question. I'm getting a little scratchy here. Hi, Kay Peters. Thanks, Lori, for all I've learned about the law. Now I can watch trials and understand. Well, that is my whole point. That is what I love to do. I love to teach, and I really enjoy talking about the law and about the ins and outs of it, and talking about it in a way that that you don't have to be a lawyer to understand it, because we need access to our system. We need to know how our system works. And we don't need to feel like we need to be lawyers before we can figure it out. We watch a trial and we're like, what the heck did they just say? So I'm here for it. I'm here to interpret it, put it in layperson's terms, explain all this silly Latin stuff we still use, and to put it in terms that that make sense. So when we talk about this case, yeah, I listen to it and I'm like, ooh, that's juicy. But ultimately, it's about being able to sit here and talk to you about why I think Judge Toll was a great choice, or why I think it's interesting that she made that ruling. So it's great fun, and I love doing it, and I'm glad that y'all get something out of it and keep coming back every week to join me for this. I know that today was a little bit more of a deep dive into into the law nerd realm, and a little bit less of talking about this case and that case. But um, I think y'all were there for it, so I'm glad that you all joined me. Hi, Carolyn. Would you consider a subject for one of your future books, Women in the Judicial System? You know, it is a book I have considered often. There are a couple of books about it, and a couple of books specifically about specific women, um, including some great books about Ruth Bader Ginsburg and Sandra Day O'Connor. Maybe the time has come for a book about women in the law in general and in the judiciary. It's certainly something I've thought about before. When I started law school in 1989, my law school class in Oregon, now I have to say that Oregon has tended over my 30-year career to be pretty progressive when it comes to women in the law and women in the profession. Um, but when my law school was the first class in my law school's history where there were as many women in the class as men. Before that, it had always been more men than women. So I think we've seen a real shift in the profession. And it is interesting that we've also seen a real change in the ideas around work-life balance as a result, because women are more inclined to say, hang on, I need to balance being a lawyer with being a mother and being a parent and being a, a sister and a daughter. And I think women are more inclined to press for that work-life balance. And so I think we've seen some changes in the profession. We are not seeing as many young associates go into big law and grind out the 60 and 70-hour weeks, week after week after week. And I think that it has to do with the fact that women are really less inclined, and we're making up 50% of the bar these days. They're less inclined to take those jobs, and so firms are having to figure out ways to make their employment of young lawyers more humane, because their pool has shrunk, and there are just not as many young lawyers coming out of law school who are willing to work under those conditions. So, I think it's an evolution, and it is something I'd be interested in thinking through. Thanks for the suggestion. Trying one more, as chat asked. Oh, sorry. Um, sometimes we miss them. Please, if we miss your question, repost it. We don't mean to overlook your questions. I want to answer everything. I want to answer every question. Sometimes we get to the end of the hour and I say, okay, I'll try and catch up with the questions in the chat or in your comments, but I really do want to answer your questions. So if for some reason they get overlooked, repost them. Did you see an objection to Chad's attorney withdrawing filed tonight? I have not seen it, but I will look it up. I'm certain that the prosecution is going to object. That hearing, by the way, is tomorrow morning. If there are any unusual developments, I will go live tomorrow to bring them to you. However, I don't really expect it. So let me just talk a little bit about Daybell since we're onto that subject. I didn't see the objection. I'm certain that the prosecution did object because they don't want the trial set over. They've done all this preparation and they're ready to go. However, it's a death penalty case. If this were not a death penalty case, I think it's possible Judge Boyce could say, you've had plenty of time. You need to go to trial in April. But it's a death penalty case. And I think the judge will not risk a trial being overturned because of this. I agree. It's chicken shit. I mean, I utterly agree that John Pryor should have done this months ago. He's going to weasel and he's going to say, oh, well, I thought I was going to get this death penalty qualified attorney approved by the state, and the state's dragging their feet, and I can't get this person approved, and now it's too late, they're of no use, and so poor me, and I'm in this all alone, and blah blah blah. He's going to do all the weaseling to justify what he's done. But I absolutely agree that he's had almost a year to figure this out, and he should have figured it out a long time ago. He didn't. And regardless of what consequence that might have, it can't redound to Chad Daybell. Okay. I realize that nobody likes that. I don't like it. But the consequence can't be to Chad Daybell. The consequence has to be to John Pryor for his decision to wait until the last minute to withdraw. So I think what we're going to see is we're going to see the judge grant the motion. I think we're going to see the judge has already had a heads up that he needs to appoint death penalty lawyers. I think what's going to happen tomorrow, this is going to be a 5-minute hearing. I would be shocked if it's anything but that. The judge is going to take up the motion. He's going to give John Pryor an earful. He is going to grant the motion. He's going to have 2 death penalty attorneys teed up. He's going to appoint those death penalty lawyers, and he is going to set a status conference in a month or 2 and to set a trial date. And I think that's going to happen. And I think maybe at most we're going to see a 10-minute hearing. Now, I could be completely wrong, but I think based on where the case is at and the fact that it's a death penalty case. Now, yes, John Pryor said in his motion, oh, I would stay on the case if it weren't a death penalty case. And please, sir. And I don't think the judge is going to get rid of the death penalty simply because John Pryor isn't death penalty qualified. Nice try, John. No, that's not going to happen. I firmly believe, and all of the information I have, is that the state has made a plea offer to him to give him the same sentence as Lori got, life without parole. For whatever reason, Chad Daybell, in his naive and immature and not the brightest bulb on the string reasoning, has decided that he is less culpable than Lori, hasn't done anything wrong, and therefore shouldn't get the same penalty that she got. And I don't think that John Pryor has been able to explain to him the theory and the legal theory of accomplice and conspiracy. And so Chad has not been able to understand that. And I'm sure that John Pryor has told him on more than one occasion, take the deal, because otherwise you're going to get the death penalty. And Chad hasn't done that. So now, and I'm sure that negotiation may be part of what delayed Pryor in withdrawing, was he really felt, and all reason would say, the case should resolve with a plea. I mean, any lawyer would say, wow, after Lori's trial, whew, yeah, we need a plea. You need to plead out and avoid the death penalty. But Chad has not been willing to do that for whatever reason, whatever his tortured reasoning is. And John Pryor has not been able to explain to him in a way that he understands why it's a good idea. So they're both stuck. I mean, you really are at that kind of impasse. And so now we end up with John Pryor saying, okay, we got to go forward on a death penalty case. I can't be ready. I agree that he should have done it a long time ago, but here we are. And I don't believe that Judge Boyce is going to risk making John Pryor go forward in April and end up having the case overturned on appeal and going back for a new trial. One of the reasons I say this, let's remember, Judge Boyce is from Fremont County, and he understands the incredible expense that Fremont County, this tiny rural county, has borne. So every taxpayer in Fremont County, every citizen of Fremont County has been on the hook for hundreds of dollars in contributing to the prosecution of Lori Vallow. We're talking probably $4.5 million have been spent already, and Chad hasn't even gone to trial. So I think that Judge Boyce is going to say, I am not going to inflict on the citizens of my county the expense of a trial that I am confident would be overturned by the appeals court and would have to be done again. I'm not going to inflict that on the citizens of my county. I'm going to say, yeah, okay, I am not happy about it. I'm going to give John Pryor holy hell over it. But ultimately, he's going to grant the motion. He's going to appoint 2 death penalty lawyers, and that trial is going to happen sometime, maybe late 2024, more likely 2025. One of the issues that I think is going on in the state of Idaho is there is a shortage. There is a national shortage of public defenders because nobody will pay their public defenders what they should. And on average, public defenders make a third of what their counterpart prosecutors make. A lot of them, most of them, get health insurance, don't get pensions. It's all done as private contractors. It stinks. And so it's getting very difficult to find public defenders in general. It's also getting very difficult to find public defenders who are death penalty qualified and are willing to take on a case that's going to eat their practice for a year. And they're literally going to be taking a cut and pay for a year in order to take the case. So that's a problem. What it means is that there are somewhere around, and it varies as people come on and drop off the list, but somewhere around 25 people on the death penalty defender list with the state agency, the Public Defense Services. Of those, not all of them are qualified to be the lead counsel. Some of them are only qualified to be second chair. So if you winnow out all the people who are not qualified to be first chair, maybe you get half. So maybe now you have 15 death penalty qualified lawyers. Then you weed out the people who already have big cases, like the Koberger case and some of the other high visibility cases that have happened recently. Now maybe you're down to 5 or 6 who actually are available. And then you have to go to them and say, well, will you take the case? And they don't have to accept those cases. They're not required to. They can say, look, it's a high visibility case. There's a lot of liability floating around on this case. And I am not really sure that I want to take that on for the paltry amount the state's going to pay. So I think that that there is a risk that they may not be able to find somebody right away to take the case. We'll see. I mean, Judge Boyce has had some time to talk to the state public defense folks and to come up with candidates. So if there is someone available, I suspect he will appoint them tomorrow. So good question. Like I say, I haven't seen the response, but I will look at it. And if it appears that that something different than what I predicted happens, we'll go live and talk about it tomorrow. Hi, Jill Schneider. Back to the Murdaugh case. I'm still trying to figure out why they went after Becky's son. What is that all about? I'm not sure that it has anything to do. In fact, I'm pretty sure it doesn't have anything to do with the jury tampering. I do think that it has something to do with her unethical conduct and with the way that she's conducted herself in the courthouse. There are allegations that she gave herself bonuses out of a fund that was intended to support child support collection. There are allegations that she collected money from people to give courthouse tours, that she then misappropriated that money into a personal fund. And there are allegations that have absolutely nothing to do with whether or not Alec Murdaugh gets a new trial. And I think those issues have more to do or the business about her son has more to do with that. I think my understanding is that when those ethics complaints were made, she then went to her son and had her son start monitoring the other people in the courthouse's accounts to see what they were saying about the ethics complaints. So I think it has more to do with that than anything to do with the allegation that she tampered with the jury. But the jury tampering allegation was just sort of the canary in the coal mine. I mean, that really was oh, by the way, there is a much bigger problem going on here. There is a much bigger problem about Becky Hill's credibility, about her honesty, about her integrity, that goes well beyond her potential tampering with juries. And remember, she was the clerk of the court for a lot of other cases. One of the things that happens anytime something like this happens, where something is, whether it's a law enforcement official, a crime lab person, is their honesty is brought into question, then every other lawyer in town starts looking back at their old cases and saying, wow, I wonder if she was talking to the jury in my case. I wonder whether or not she had anything to say to the jurors in my case. So then it's like a Pandora's box. It opens up this can of worms that suddenly brings the verdicts in a lot of other cases into question. It's the same as if you have a dirty cop. If you have it came up in the Melly case where the cop was accused of having said to another cop, "You were here when I seized this person's phone," because he didn't have a warrant for it. And he said it in front of the DA, and the DA said, "Oh, wait a minute, hang on, that's not okay," and so outed the DA who had told him to stay quiet about it, and outed the officer. Promptly then what happened was every lawyer in town started looking at all their old cases, and any case that officer was on, they started calling into question whether or not that person had properly served warrants and properly followed procedure in those as well. And happens if you have somebody from the crime lab who is accused of falsifying results, then suddenly every case that crime lab tech worked on suddenly becomes suspect. So I think it's a much bigger picture when it comes to Ms. Becky. I think there are going to be a lot of lawyers who are going to be saying, I want to go back and revisit whether or not she tampered with my jury in other cases. So that's going to be an interesting and ongoing question. Hi, Greg. Do you think this will affect people not wanting to be jurors in the future? Absolutely. I think it has a huge impact on people saying, wow, I don't want to get drugged through this. Not only did I not want to be on a high profile case, I don't want my face out there. Not only, and remember, this is a small community where everybody knows everybody. So it's worse. You don't have any anonymity. You're not able to say, I don't know what you're talking about. And there's no way to be protected from that. And I think that it's happening in a lot of high-profile cases. It happened in the Maya case, in the Protect Maya case. Now that was a civil case, but the defense brought up, when the defense didn't like that herkin big defense award they got, they immediately went back and looked at the jury and said, oh, there was untoward things going on with the jury. And the jury was brought into question, and it had to be brought in and be questioned about it. And, the judge did exactly the same thing that Judge Toll is doing at this point. She said, the judge in that case said, I am going to ask very specific questions of this juror, and that is all you get. You don't get to dive into the juror's deliberations. You don't get to dive into the other jurors. You don't get to dive into any of that. You don't get to dive into the juror's credibility and what he told his wife, and you just don't. And so that was a very straightforward questioning, and boom, they were done. The judge said, no harm, no foul. So I think that's what's going on in a lot of cases. There was a recent case where the jurors, the Adelson case, Charlie Adelson's case, the jurors got in a group text together. It's very clear from the group text that they weren't talking about anything except where to go to lunch and if they were going to meet, and what time things were happening. And it was a group text so that if somebody left the courthouse, that they'd be able to reach them, that they'd all get the same message at the same time. And that Adelson defense went nuts over the fact that they had a group text. So then they had to produce the group text to the judge, who said, there's nothing in here that discusses the case. But that's happening all over. And I think it does make people less inclined to sit on juries. It's a hardship. I mean, a lot of employers don't pay their employees for jury leave. In a lot of cases, it takes them away from their families, from other obligations, and so it's a lot. And you get these high-profile cases that take weeks and weeks and weeks. And then on top of it, you say to them, oh, by the way, we think you did something inappropriate, so come on in and let us question you about it. Yikes. Yeah, I do think that it has a chilling effect on people wanting to sit on juries. Hi, Polio. How is Potty even getting paid? I think you're talking about John Pryor. What we know from his affidavit is that Chad was declared indigent a year ago in January. It's interesting that I don't recall that hearing, so it must have happened during a hearing behind closed doors, which Judge Boyce is sort of famous for. And I think that is a really inappropriate thing to have done behind closed doors. The public has a right to know whether or not John Pryor or Chad Daybell is indigent, and whether or not their tax dollars are going to be paying his defense. So I don't know, because that was the first I had heard of that he'd been declared indigent, but it's in Pryor's motion and affidavit. So he's been indigent. So we don't really know how Pryor's been getting paid. We know that when Lori and Chad came back from Hawaii, Chad had about $130,000 left from Tammy's life insurance, which means that in a matter of a few months, they had spent $300,000. Where that money went, your guess is as good as mine. But when he got back, he had $130,000. He had about $85,000 in, good question, Mary. He had about $85,000 in equity in his house, which he signed over to John Pryor. I figured that was all exhausted a very long time ago. So I don't know that anybody really knows. I heard a rumor that some of his followers might be helping him out financially, but I don't know whether that's true or not. That could be pure speculation. So, can Judge Boyce censure John Pryor? He could hold John Pryor in contempt, but I don't know that that's a really effective threat or really effective way of punishing him. The judge also could file a complaint with the bar. He could file an ethics complaint, and he could say, I believe that he's violated his ethical obligations to zealously represent his client, and not to do anything that would hurt his client. But here's the thing. John Pryor is going to go to the ethics board, and he's going to say, I didn't do anything to hurt my client's right to justice. If anything, I helped him out because now he's got more time for his lawyers to prepare his case. And he's got 2 lawyers instead of 1. And he's got a death penalty qualified lawyer instead of one that's not. So I think it's going to be a tough sell to censure John Pryor. Nobody's going to be happy with it, and everybody's going to think he's a jerk. But I don't think he's going to face any particular consequences for it. The money, time, and inconvenience to 2 county courthouses. Liz, I don't think so. I think that he is. If it were 2 weeks before the trial, I think it would be different. But we are 3 months from the trial. Now, 3 months before a death penalty case is, nothing. But I don't think that he is going to face consequences for it. I don't think anybody's happy about it. I don't think Judge Boyce is happy about it. But I don't know that there is a basis for an ethics complaint, and I don't really know that there's a basis for any sort of, he can give him a thorough tongue lashing, but at the end of it, that's going to be the end of it. So, silly me. This is a good question. Do you think Chad will testify? I think it's possible, because I think he thinks he's not guilty. I think that he honestly believes that he didn't have any part in it. Now, I don't know how he gets past the fact that he and his son Garth are the only 2 people in the house the night that Tammy dies, and that she's lying next to him in the bed when she dies. And that the coroner has said this was a homicide. This was a murder. So I don't know how he gets around that. But I think he thinks he's not guilty. Angela, I would love it if Chad would testify. That would be his big day to prove to everyone he's the prophet. Yeah. Well, I don't know whether he would take the same tactic that Lori did of doubling down on her belief. I don't think he'll go there. For one thing, I don't think he will embarrass his children by doing that. And I think he feels like that might embarrass them. So but I think he might testify, because I think he thinks he's not guilty. More importantly, I think he thinks he's innocent. That's different. What was that about somebody's beautiful daughter? Wait, Chad has followers? Ew. Oh yeah, Chad has followers. You're going to have to buy the book to get the full scoop, but because it's a much bigger story than I can go into. But yes, Chad and Lori really were part of a much larger neo-fundamentalist movement within the LDS Church. And so there are other people who ascribe to the same beliefs that he does. Now, whether they actually follow Chad Daybell as a prophet, or whether they simply support him because they share these beliefs in returning to the fundamental beliefs of Joseph Smith, claiming that the current day church, because of all of their more progressive decisions, is now in apostasy. their claims that they need to return to Joseph Smith's teachings on race, on polygamy, on multiple probations, all of those things. So there's a much bigger movement within the LDS Church, and Chad and Lori were a part of that. And I do think that there are people who still support him because he shares those views. Are they people who see him as their prophet? I doubt it. But I do think that they believe that he's a visionary and that he that they share his views. There we go. SM, my beautiful daughter was just offered a Bachelor of Law with honors in Australia. Any advice, Lori, for young new law students? Oh gosh, lots of advice. I guess, you know, studying law varies in different countries and even from school to school and state to state in the US. It can be a highly competitive environment. And I think that it's really important to keep sight of what's important to you, not to lose sight of, to get caught up in that really competitive place and to let it run you, because it will. And you will get, I mean, here in the US, they say the first year they scare you to death, the second year they work you to death, and the third year they bore you to death. And it really is to some extent true. You spend the first year trying to figure out how to go to law school, how to read a case, how to figure out the rules, all of that stuff. It's like learning a whole new language. And you're immersed in that for the first year. By the second year, they figure you know how to do this, and they literally dump the work on you. And it's more than you can ever get done. It's part of the mental preparation, the sort of hazing, if you will, the teaching you how to think like a lawyer. Part of it is that overwhelming information overload and learning how to sort out what's important and what's not. That's part of the exercise of second year. By the third year, you're like, oh my gosh, this cannot end soon enough. So I think my advice is always, don't pursue the law because you think you're going to make a lot of money. Do it because you love the law, because you have a passion for it. You can't see yourself doing anything else. Do it because you love it. And the rewards, both financial and otherwise, will come if you're doing what you love. And I know that everybody says that, and you know, it is a luxury to be able to do what you love. A lot of people don't have that luxury. But if the law is your passion, then go for it. But definitely always keep sight of who you are and what's important to you. So when I went to law school, I made two rules. One, Friday night would be date night with my husband. And two, I would go to church on Sunday. And you have to know that the hours of the day are precious. So to take a couple of hours out of your morning and go to church, it's a lot. It's 2 hours that you could be briefing cases and doing homework and figuring out what you do, writing papers. And but it was huge for me to make that commitment, because it reminded me that there were other things going on in the world, even though I was in the law school bubble. And that's hugely important. When I did my undergrad work, I went back to school as an adult in my late 20s. And when I did that, I treated it like a 9-to-5 job. And so I'd go to school in the morning, I'd do my homework, I'd come home, I'd go to class, and I still skied every weekend. And got almost a perfect GPA. So that's the way undergrad is. Law school is a whole different level of competition, of demand. And the precious thing for me about law school is I graduated 31 years ago, and I still maintain contact with a core of people I went through law school with because we shared that experience. And it's the same. My husband's a retired military aviator. He's a fighter pilot. And he shares that same sort of camaraderie and brotherhood with the people he went through flying training with and that he flew with. And it's very similar. So I think you will form amazing friendships. You will have amazing experiences. And the more that the people around you who love you can keep you level, the better. One of these days, I will tell you my horror stories about law school and about the number of times I melted down and my poor husband had to pull me off the ceiling, but for another day. Let's take a couple more questions and wrap up for the evening. Hi, Annie S. Oh, good question. Could Jim Archibald represent Chad? I know he's representing Jeremy Best and his time may be taken up with that case. He is representing Jeremy Best. For those of you who are not familiar with the case, Jeremy Best, this is a case that happened recently in Idaho, out in eastern Idaho, where Jim Archibald is located. It was a very tragic case, a tragic case. A man who has severe mental health issues broke into the mother of his child's home. I can't remember whether they were married and divorced or whether they'd not been married, but she had custody of their child. She was pregnant with their second child. And he broke into the house. He killed her. He took their little boy, who was under 2, and left with him. Quite a bit later, more than a day, like several days later, they discovered his pickup truck parked by the side of the road. It was sub-zero temperatures and very difficult conditions. They found him naked in a sleeping bag by the side of the road, and the baby was deceased in the car. So it's a horrible case, and it is undoubtedly, he is very clearly mentally ill. So they're going to have to go through all of the mental illness issues. Idaho doesn't allow insanity defense, which means that they're going to have to present information saying that he didn't have the ability to form the mental state because of his level of insanity. And so he's got his hands full with that case. He could not represent Chad because he previously represented Lori and they were co-defendants. So it is possible that Lori told him things, attorney-client privilege things that could come to bear in Chad's case. Let's just say, for example, that Lori told him, listen, I'm not going to let you throw Chad under the bus, but it was Chad and Alex who killed the children and dismembered Tylee. That would be information that would be protected under attorney-client privilege. He would not be able to disclose that information. However, now he's in a position where he's got to go before the court knowing that she's told him that Chad was responsible. He's got to put on a case saying, my client is innocent, he was framed. So it is an actual conflict. It is not something that Lori could waive. And so he couldn't represent, neither he nor John Thomas could represent Chad. So that takes 2 lawyers off the the case. I happen to know John Thomas was also recently appointed to a death penalty case. So that's going to be, that takes two death penalty qualified lawyers off the list, away from the possibility of being appointed. So they wouldn't be available even if they weren't representing other death penalty cases. So, can Judge Boyce hire death penalty lawyers from California or another state with 10 tons of death penalty lawyers? Good question. Lawyers can apply to be to appear pro hac vice, which is what what's her name, Rachel Smith did for the prosecution. So she's not licensed in Idaho, but she applied for permission to practice in Idaho for the purposes of that particular case. Sometimes judges will allow that, but Judge Boyce couldn't put a call out to California death penalty lawyers and say, anybody want to come up here and take this case? I doubt seriously you're going to get an out-of-state lawyer who's going to come to Idaho with what they pay and take a death penalty case. They probably make more money in California, frankly. California probably pays their public defenders better. So I can't imagine that they would be able to do that. You cannot go practice in a state where you're not admitted to the bar or admitted for a limited purpose under the pro hac vice rules. So pro hac vice is another one of those Latin terms that we still use. But so the answer is a limited no. I mean, it is possible that somebody from another state could come and say, I want to represent this person for the purpose of just this case, but I don't see that happening. And frankly, I just, every state in the country is experiencing a shortage when it comes to public defenders because of this, because they're not paying enough. And the caseloads were crippling. I mean, when I left public defense practice, we were complaining because first of all, they were paying us per case, which is patently an illegal way to pay lawyers, because it means that the faster I turn your case, the more money I make. And that pits my interests, my financial interests, against my client, gives me an incentive to settle my client's cases and plead them out rather than take them to trial, because I make the same amount of money whether they go to trial or whether they plead out. And the more cases I can turn over, the more money I make. It's a terrible system. Oregon has been in the process of changing those rules, but it has been a slow, difficult slog. So, but when I was, before I left practice, I typically had between 90 and 100 open cases at any point. And those were all public defense cases. By that time, I wasn't taking any retained work because I simply didn't have time for it. And I was doing primarily child welfare and juvenile dependency and delinquency cases. So the bulk of what I was doing were cases where children had been removed and were in foster care. And there was a time when I had 150 children on my caseload. So it's a lot. And that is why at this point, young people who are coming out of law school, we're talking about, going to law school, people coming out of law school don't have any interest in going into public defense. You can't blame them. Because every time the state, every time you say to the state, our lawyers need more money, they say, okay, but you got to take more cases. And it just gets to the point where there's no way that you can do justice to any one of those cases. So it's a no-win situation. And until every one of the states comes to the realization that qualified lawyers are not going to become public defenders without some major overhaul of the way they get paid, until that becomes clear, they're going to suffer like this. In some states, prosecutors are having to dismiss cases because there are no public defenders available. And they end up just sitting, and cases can't be prosecuted because there are no public defenders. So it really is, I mean, they throw around the word crisis a lot, but it really is a crisis. And to date, the states have not been willing to confront it. And it was a very frustrating situation. The governor of Oregon for 8 years was a former juvenile court public defender. And yet we couldn't get any reform during her 8 years. And she left, and now there's another Democrat governor, and she's not doing any better. So it's a perplexing problem, and one that the states have not been willing to confront. Very unfortunate for defendants who need competent counsel. So good questions tonight, guys. Oh, go ahead. Let's take one last one. Hi, Nikki Mick. Can a rejected plea deal be used to raise concerns with your client's competency? Ooh, good question. Plea negotiations are generally not made public, and they're not to be used against the defendant. Let's say the prosecution makes a plea deal and they think it's a sweet plea deal. They can't then, if the defendant turns it down, they can't then come to court and say, hey, we offered this guy a deal and he didn't take it. So if you, the jury, give him a consequence bigger than he would have gotten, too bad, so sad. That's not permissible. And so plea negotiations are kind of tenderly treated. I think that if what you're saying is a defense attorney can say, listen, I've tried to have this conversation with my client and he keeps rejecting this plea deal and it doesn't make any sense, then perhaps the lawyer could say, I'm concerned about my client's competency to fully understand the plea deal, the plea offer. And in that case, maybe what the lawyer would do is go back to the prosecution and say, listen, I have done everything I know how to explain why this is a good deal. And I agree, it's a really good deal. I've done everything I know how to do to explain it. I am deeply concerned that my client didn't take it. And I think that signals to me I'm worried about his competency. So I may ask for a competency evaluation. That also protects the lawyer by saying, I've done everything I can to explain to this guy why he needs to take that. Because the lawyer doesn't want the person to go to trial and then him to come back and say, well, I'm filing an ineffective assistance of counsel because my lawyer didn't explain to me this plea deal, or I would have taken it and I never would have gotten the max sentence. Hopefully that makes sense. So yeah, I think there are instances where somebody might say, I'm not sure my client's playing both a full deck. I don't know if that applies to Chad's case, though. I think he's just dumb. I think he's just not the brightest bulb on the string. Wristbands, you can still get them. Once I can get out of my driveway, I'm going to check the P.O. box and get wristbands out to everybody because we certainly, no matter when Chad goes to trial, we certainly want to make sure that we are flooding social media with those wristbands, with pictures of those wristbands. So please, if you still have questions, I know we talked about a lot tonight and a lot of it was certainly more deep dive than usual. You know, we got into some deep stuff tonight. If you do have questions, please post them in the links below, in the comments below, and I will answer them. I do appreciate it. I do read all your comments. I don't always respond to every one of them, although I try and like them. But I do read them all. I usually get up on Thursday morning with my coffee and read all your comments, and I do peruse the chat as well. So please, if we didn't get to your question, post it down below. If for some reason you're one of those folks that likes to sort of lurk in the background and doesn't really want to post questions in the chat or in our comments, drop me an email. The email's in our show notes, and certainly I answer those. So please drop me an email as well. I want to thank everybody for being here tonight. It was great fun to get down in the weeds. Hope you all had your ghillie suits on. Ghillie suits, those are those ones that make you look like a bush, like Alex Cox had in Lori's garage. Anyway, thanks for getting in the weeds with me tonight. If by chance there's anything exciting that comes out of the Chad Daybell hearing tomorrow, we'll go live for a short live. Also, tomorrow are going to be the oral arguments in the Supreme Court of Indiana on the Delphi case. So that will be interesting to follow up on as well. It's unlikely that they will make a decision. I'd say it isn't going to happen. They won't make a decision tomorrow, but they'll issue a written decision shortly after. So we'll be interested to hear that. Thanks tonight for joining me. I hope you will join me next week. We'll have a lot more to talk about, I am certain. And in the meantime, have a great week. Thank you all for joining me. And thanks, Jen, as usual, for moderating. I'm going to say good night.